lot of the planning that I do is to try to figure out a little bit more about the children and grandchildren. I mean, what are they like? What protections do they need? Because mom and dad have the ability to give them more protection than they can do themselves.
Welcome to the Answers for Elders radio show.
And welcome back, everyone, to Answers for Elders Radio Network, heard across the USA on your favorite podcast channel and on YouTube. And certainly we're excited to have Steve Waltar with us, estate planning attorney. And we're coming up, I know we're recording this in December, but obviously it's a new year upon us. And one of the things I have always heard is like, when the new year happens, new laws go into play. A lot of times there's a lot of things that happen. And so the big $60,000 question is, when should your estate planning documents be reviewed? When should they be updated? So welcome back, Steve.
Thank you. Glad to be here. Yeah, the $64,000 question. Hey, when should I update my estate plan? Or how do I know? It always depends, right? That's what an attorney says. It depends. I think it's wonderful to check in with the attorney annually. In fact, I'll talk later about our VIP plan that offers that. But as a rule, we tell clients every 5 years you should come in to kick the tires, do a free look. Because by then, your goals may have changed, your assets have certainly changed. It might even be your wishes and goals have changed for your beneficiaries. You're right that on an annual basis, laws tend to change. So people usually come to us because there's changes in people, right? This could be, can you imagine that a divorce, either of the clients or their children, would affect the estate plan?
Right.
Radically, we could talk about that. In fact, our powers of attorney say upon the filing of legal separation or divorce, that the spouse can no longer, have power to drain accounts and, have financial power or healthcare power, et cetera. A lot of law firms don't have that. A lot of forms don't have that. If someone did their own little form, it wouldn't matter. Obviously, divorce is huge, right? Who you want to get your assets, who you want to be in charge, that's a big deal. But it can be the children as well, right? Now, if the daughter got married and her last name changed, that's not going to mean we couldn't find her in the event of a death to be a beneficiary. But if one of the kids went through a divorce or got married and you wanted to treat the step grandchild as if it was a grandchild of the clients, the upper generation, that takes planning. It doesn't happen automatically. So changes in people, right? That's good. Changes in agents. That's like, usually people will come in and they say, oh my gosh, my agent has passed away, so my documents won't work. Well, if they were drafted well, there's probably a backup agent or two. But sometimes you just flat out don't want that person to be your agent.
Yeah.
So that you want to change that, right?
Right.
So you were hinting on laws. Laws do change. The healthcare laws changed recently.
Yes, they did.
It was so bad they didn't even say we're replacing this RCW with this one. They totally gutted it and left it elsewhere.
Right.
I haven't gone to the hospital. I've been to the hospital to visit clients, but I haven't seen if they won't honor the prior documents. But every time a client comes in now, I'm updating their healthcare powers to make sure it has the current language.
Absolutely. And Steve, one of the things, I get calls from families all the time, like, here's a typical call. My husband needs care. We can't afford it. And I'm afraid I'm going to lose my house. And of course, we've had this conversation before in your content about how, how your husband or wife, your spouse can get the proper care without losing the house. But that's a legal situation. But talking about, I can imagine that changes your entire estate plan, would it not? Because if you're dealing with a Medicaid situation or a special needs trust of some sort like that, that's going to make a huge difference on everything else, is it not?
Yeah, absolutely. The stages, right? Often people come in to do a will because they have a child, right? When my kids turned 18, they got powers of attorney. They didn't need a will. When young families have kids, they need to list a guardian, all that sort of thing. Often when people get enough assets that they're more than 2 million, they do a living trust. to double their exemption, avoid court, etc. But like in your circumstance there, if the concern is they're blowing through assets and you may want to qualify for Medicaid, we probably want to revoke the trust,
Right.
plan with the will, and have a safe harbor trust in the will to say, hey, the state can't put a lien on something.
Right.
If I die, I have a special container for my spouse. So it's very important for the attorneys to know the assets along with the goals, or we can't
Yeah.
plan.
Yeah. One of the things I think that you've talked about is now you've got inheritance, you want to give an inheritance to your loved ones. But there's also creditors, there's taxes, there's remarriage, all kinds of things that happen. How does that affect the estate planning?
I like that. So I tell people, look, we have attorney-client privilege here. I need to ask you about your assets and your family, and I'm asking you some nosy questions. I actually say that just kind of playfully. And when I'm asking about the children, I am trying to draw legal conclusions about whether they'd be good power of attorney, successor trustee. Would they be good at that, or not good at money? Or maybe they're about to go through a divorce, or maybe they've been sued before. Maybe we need to do asset protection for the children.
Right.
Right. And so we need to know about that because there's different ways, when you give the money outright to children, it's like you're squeezing toothpaste out of the tube. It's on the table. They could get it. A divorcing spouse could get it. A creditor could get it. The state of Washington could get it. So a lot of the planning that I do is to try to figure out a little bit more about the children and grandchildren. I mean, what are they like? What protections do they need? Because mom and dad have the ability to give them more protection than they can do themselves. Once you have the assets, it's a little harder to do things to protect yourself. But when you don't have them yet, you can structure them. Oh, maybe this should be a generation skipping trust.
Yeah.
So it can be as simple as this person should not be my agent, or you need to be with someone that's a little bit more organized.
Yeah.
Or it could be, gosh, we would never give you money outright. That's not very helpful.
Yeah. Yeah.
It could blow your entire state fund, your special needs benefits could be taken away if you gave them money.
I have a friend that has a daughter as a single mom, and she's been giving her money every month, right, to help her. But then she has a son who she loves equally. And she's asked me, she goes, I think I don't want to offend my daughter, but she's kind of getting her inheritance now, and I don't think it's necessarily a bad thing that there is some defining situations. So having that reviewed every 5 years, you have opportunities to help them structure a way that is fair and balanced and equitable, according to the wishes of your client.
There's nothing as unequal as the equal treatment of unequals.
Yeah.
I have 2 daughters. They're wonderful. They're different. My clients have multiple kids frequently. They also are people without kids, but they're not all the same. They don't all have the same needs. And so if you're able to communicate what's going on, and you maybe have a makeup provision, maybe someone did get kind of an advancement. Maybe someone's living in the house and you want them to be able to get the house, but it probably shouldn't be in addition to their share. It maybe should be part of their share. And so how do you value that? When people are giving health care, do you honor that? Do you not do this? If you don't communicate at all, the likelihood for disharmony or family fighting goes up dramatically.
There are people that have assets that need to have what you provide, but there's other options for people. They still need to have a will. What are some of the documents that everybody should have?
Well, pretty much everyone needs powers of attorney because, married folks can't sign for each other, at least not legally, right? You can't sign to borrow money. You can't, if you're on a joint account, that's one thing, but you can't legally sign for someone else. So most people, if they're competent, right, they're over 18, they need powers of attorney for finances and for health. Now, do they want immediate powers for people or not? Well, that's, with a financial matter, you may not want someone to immediately have the power to do things. You may want it only in the event of incapacity. So that's a personal choice. Along with that would be like a HIPAA authorization. So that people have authority to have access to information. Now, none of that says who gets what, when, or how. So then you get into, well, what do you own? if people, you could have a really large brokerage account and you want to give everything to kids, you could just make it transfer on death. But if you want to give with a little more control, then you need a will or a trust to say how.
Right.
And if you have real property, it used to be you had to do a living trust to avoid court, but you can do transfer on death deeds now as well.
Sure.
So when I have people and they want to avoid court, I ask a lot of questions about the children to figure out, could they just have it? Or you want to give one child something and another child something else? And maybe you still want to trust because you can just do more things. But sometimes you can, your beneficiary designations can take the need of a will or trust.
Absolutely.
It depends on goals. It depends on the size of the state. Do you have assets in or out of state?
Yes. And so, Steve Waltar, you have information on your website, do you not, about all of this stuff? How do they find you?
Yeah, you could, if you could spell my last name, you go waltar.com. So www.waltar.com. And there's just loads of material on that. You could also just give us a call, 425-455-6788. 455-6788.
And all Steve's information is on Answers for Elders as well, under our specialists section. So we're very excited to always have him as our touch point, and certainly making sure that later life goes a lot easier. And believe me, I ran into so many roadblocks and different situations when I was caring for my mom that I should have known about before. So this is something that being proactive and to check with someone like Steve is really, really important. So thanks so much. And Steve and we're going to be right back, and we're going to talk about how we make updates to your estate plan. What is most important, and what are the things that you need to think about right after this? Did you know that you can discover hundreds of podcasts in our library on senior care? So visit our website and discover our decision guides that will help you also navigate decision making. Find us at answersforelders.com.